I'll just point out the parameters, I will not read it, which simply says it's a procedural requirement. My lords, may have page 5. Page 4 bottom. It's a thin submission.
Have you handed over?
Well, so I had to. I have extra.
Yes.
I'm sorry, because one is not in the form of paper. My-
Yes, please. No, you're referring to this one.
My lords, my name is Pallav Mongia. My lords, should be filed in my name.
Yes, that's there.
That's the one. That's the one. Page 4 bottom is just a 8 pages submission. My lords.
Yes.
Page 4 bottom.
Yes, where we can refer to MMTC.
MMTC, my lords, absolutely, my lords. And honestly, I won't read the paras. But my lords, though these judgments say they are procedural in nature, but my submission is it should be mandatory, but in form of a consent, not in form of a pre-application. It's not a trigger point. It's more of a case of ex post facto compliance. Because if the because my lords, once the court has made up its mind,
You can understand if you say that oral application, written application may not be necessary.
my lords,
But on an oral request, it will be made.
my lords,
Then how can it be post facto?
no, ex post facto in the sense ki first the courts made up their mind and then they seek consent, not that after the tribunal exercise. My apologies.
Both.
I'm sorry.
Consent of whom?
Consent of one of the parties. Because it should not be an exercise in futility for the parties.
I think we're going in absolutely. Look, it's for the court to decide. Courts know how to deal with it. When objections are there, normally what happens? The party which is objecting, it can be two situations.
Right.
The party which is objecting to the award may come forward and say, please get it corrected. But the greater possibility is normally the party which is defending the award
Correct.
and
Correct.
gets confronted with a situation where they are not able to defend, ask them to be sent over there.
So that winning party will make a choice that, for example, mitigation of damages ground is not there.
The party which wants the award to be, defending defending the award. Like in a given case, it can be the other party.
Exactly, Milo. That's my point.
But normally a person which is defending the award find it's impossible to defend it. So they say, please send it.
Exactly. So
But
it may say, look, mitigation of damages considered.
we should not now go into say how should application should be moved, whether it should be.
No, that's exactly my point, my lords. If my lords were to say that not a application
The
mechanism.
question is whether any modification can be done.
Correct. So,
To what extent?
correct, my lords. Correct. So this is a process which will trigger that power.
The language is very clear, where it is appropriate and it is requested.
So requested. It is not an application.
So even if a party makes a request, the court finds that it is not appropriate.
Correct.
Court may still reject it.
Correct. Now, I just point out 2 page numbers. I won't even take my loss to that. There are 2 Singapore judgments which are referred by the learned solicitor in his written submissions. And in the compilation 4, page 1772, there are instances where the courts themselves said that you please address me on 34.4. The court invited submissions and it's recorded as part of the transcript, not just a recording in the law reports.
What is the name of the Singapore case?
I'm sorry. Manoj, one is Bagadia Brothers.
That's Indian case.
No, Manoj, that's Singapore, Manoj. Bagadia Brothers versus Ghanshyam at page 1772.
Volume 4. Yes.
In the first para itself, 4th line, my lords. On 12th April 2022. I'm sorry, Justice Vishwanathan.
Right, yes. What is the page? 1770. Yes.
My lords, fourth line from the top, para 24. My lords have it, my lords. On 12th April 2022, I further directed the parties to address me on the applicability of 34.4 of the model law to the present application and whether it would be appropriate in the present case to remit the award to the arbitrator. There was no application. An objection was subsequently
Why are you
taken.
going into all this?
I'm going for all this.
Courts know how to deal with this issue.
No, Milos, because it has been, Milos, in my humble submission, the requirement that it should be a written application, that may not be
Just
required.
read that part.
And if it is so interpreted in such manner, then the power of modification indirectly comes.
We did not go into that question.
I bought a Milos. I just bound to share this. Then Milos, may I have just one more page? On the next page, it's a chart. I'll just show that chart and I'll just end with it, Milos. Page number 8, there's a chart in my written submissions. Milos, may I have the chart? Just, I'm so sorry, I'll trouble you. Just 30 seconds.
So we have understood the chart. It says where there's uncurable defects, it has to be set aside. Where there are
First-
curable defects,
Correct, Milos. There must
that's
be
the
a,
court to
under
try and
34.
solve it. If the court cannot solve it, then it cannot, can be sent under 34.4.
Correct, Milos. And Milos, Indian Milos, there's just one more.
Done by Mr. Datta.
Also.
Milos, this aspect was not argued.
Be used, it has to be sent back to the arbitral tribunal
Milos,
Be
in
what-
party, it should be used first, try and save.
by the 34 court itself, but it should be sent to the arbitral tribunal.
No, yes, Milos, it should be sent back to the tribunal. The court itself cannot do it. That's my humble submission. And with regard to one question that fell from Justice Vishwanathan yesterday regarding whether them can change or not, Milos, there's one judgment of BRS versus BRQ at page 1429, again a Singapore judgment, where the court itself noted that the quantum will change, but since it has to be sent back for the reasons aforesaid, all 34.2 grounds, therefore let that be the consequences. Because in my humble submission, Milos, this is not an opportunity for the parties to improve their case, but for an opportunity to the arbitrator to do a better job and ensure that the grounds are eliminated,
To remove the defects.
to remove the curable defects. Because of course, certain things can't be moved. And conclusion is on page 9, and there's a summary of my submissions also on page 1. I'll end it. I'm obliged. Okay.
But
No, you are the
I
other
it
side.
cannot be modified because of the IA was like this. That's why
No, no,
I can be taken up.
Any other names? Our bill proposition is that my lord, when your lordships are to locate the power to modify or vary, whether it is to be located as part of the power to set aside an award, which is a larger power, my lord, or is it a standalone power which stands in its own right, my lord? My lord, my submission is that as much as the power to set aside is a power, the power to modify is a power in its own right, my lord. But why I would say this is, look, I've handed over just 5 sentences note, my lord. My lord, although the words used under section 4 is only the power to set aside, my lord. My lord, but there is certainly the power to refuse to set aside the award, my lord, which is to confirm the award. There is also, my lord, the power that if the parties agree, then the court can pass an order in terms of the parties, my lord. My lord, all these powers are not expressly there, but these powers have not been expressly removed as well, my lord. So, my lord, in my respectful submission, my lord, the appellate court's power is to be traced under CPC, which says that the in exercise of appellate jurisdiction, the appellate court can set aside the award, can vary the award, can confirm the award, or with the agreement of parties, my lord, is different kind of order can be passed. Now, my lord, so long as all these powers are subject to the express limitation on the power of setting aside, which is that the court in exercise of section 34 cannot review the merits of the matter, or there shall not be any reappreciation of evidence. Now, that's the test in my respectful submission. That is the test to be applied on all these four powers. The power to set aside, the power to refuse to set aside, the power to vary or modify, or the power to pass an order in terms of the agreement between the parties.
It's an appellate power.
It's a power, which has not been taken away by this statute. The Arbitration Conciliation Act does not take any of the powers. My submission is that the express words relate only to setting aside. Right, Milord? But, Milord, the power to set aside is not to be seen as the power. Power to set aside is a power within the larger ambit of Section 34. So 34 is the larger power, in which, Milord, there is the power to set aside, there is the power to modify, there is the power to refuse to set aside, and there is also the power that if the parties are in agreement, then a different sort of an order can be passed, Milord. And the limitations only being this, that in exercise of any of these standalone powers, the court does not have to interfere with the merits of the matter or reappreciate the matter. But in that light, Milord, I have taken liberty to just request your lordship to view the third referral question. Milord, the third referral question as framed is that whether the larger power to set aside entails the power to modify. Milord, in my respectful submission, Milord, if the words, Milord, if your lordship would have the second page, whether the power, and remove the words to set aside, and it may be read like this, whether the power under Section 34 of the Act, being the larger power. So 34 is a larger ambit, will include the power to set aside and the power to modify. So Section 34, in my respectful submission, is to be read as a large power. Setting aside is a part of that power as much as the other three powers which I mentioned, the power to modify, the power to refuse to set aside, and the power with the agreement of parties. This is my respectful submission. Great.
Lords, I need half an hour for the rejoinder.
Not just now,
Huh?
not just now, not at this time.
No, not at this time. No, but I'm saying that if they could never assist your lordships, my lord, my learned friends. If
Ask to
they-
let them complete and then you can.
That's what I'm saying, my lord, that it would be fair, my lord, that they assist your lordships and
Yes,
give me
please.
20 minutes to half an hour at the end, my lord, when my friends conclude.
Yes, please.
Because I'll take a short while and then Mr. Banerjee will do most of the argument. We prepared a common compilation between the three of us so that there isn't a repetition, and that's been filed, Millers. But there's one note that we prepared. What he says. This is coming shortly at the note is coming.
Ancestral compilation, the common compilation.
Yes, Millers.
Now there are
There
three
are
views.
there are six volumes.
There are three.
There's six volumes.
There are three views which are coming. Or we can divide broadly into three views. One is that the power to set aside subsumes in it power to modify, in which cases will you modify? When will the court exercise the power of modification? Will be relatable to curable defects, not something which are uncurable by the court. But this has to be done. One aspect, one side says this should be done without going into the merit or reappreciation of evidence. There may be some difficulty in that because whenever we are going to the patent illegality public policy clause,
Inevitable.
there is element of reappreciation. But not as an appellate court, but as a court within the confines of that power. See that. The second issue which has been argued sometimes is that that in this the court may not do it it can always then exercise the power in appropriate cases under law section 4 to section 34. The third view is where the court can do it, it should do it, but where the court finds it, it cannot do it, and there is some way then you leave it to the arbitrator to carry out that exercise. That's a argument.
Correct. I think one thing we must remember, and the other side certainly must remember, is not indulging in some kind of a legislative exercise. This cannot be a de novo.
No, they have not argued.
And this-
None of them have said it's a legislative
That is-
exercise.
said-
They have gone on jurisprudence to say set aside is a wider term, so it subsumes a lesser power.
Unfortunately, the Datar has specifically handed over a page where he has said that these words have to be added, these words have to be removed. A legislative exercise can be on the face of it or by a sleight of hand. You can say, please add word to the statute and be honest about it, as Mr. Datar rightly was, by saying, please add these words. And hence, that is how the statute should read. The other way is through some process of extremely creative interpretation to such violence to the language of the statute as to amount to a legislative exercise. Well, that will also amount to a legislative exercise, and that is going to be our endeavor. That in the process of trying to remedy a perceived fault or a lacuna, we cannot do violence to settle principles of law, both of interpretation and separation of powers. It may be a crying need and a crying necessity. And I think parties probably will agree that there is a need. The worry is that if there is through a judicial interpretation.
But the moment you say there is a need, you get into a.
No, I will say something different. What I'm saying is, you may have a need. Some people may feel there is a need to intervene. In fact, my note says that there is no need. We've had 30 years from 1996 without this power of a modification. The systems have not broken down. There may be individual odd instances of injustice. That happens even in the regular courts. That doesn't mean we do away with the justice system because there are some wrong decisions. Just because in certain instances, some people will have to spend money because of remand, doesn't mean we take this entire system which has existed of setting aside alone as being the power and replacing it with something which may be far worse. Modification will become a hydra. There will be litigations upon litigations as to whether this amounts to a modification or set it aside. Is this curable? Is this non-curable? As of now, we have one round. We will have 5, 6, 7 rounds. Well, the remedy will be much worse than the disease which is perceived to exist. And I say that disease does not even exist. Who has come on a regular basis and said there is a massive problem with modification? Yes, there are problems on odd occasions. But does that mean that we do such violence to the act and the language of the act to rescue millers from this monsters hiding in the shadow? That is going to be the argument. How many every person who loses will say, don't set it aside, modify it. In every case, this is going to happen. When the matter goes to a section 34 court, one side will say uphold it, the other side say no, modify it. There will be a refusal to modify or a modification. One round of litigation that will happen. Rather than being an expeditious process of arbitration being a fast resolution process, it will be exactly the reverse. The consequence will be worse. Therefore, millets, and that is why I'm saying it may not be desirable. And if it is desirable to a limited extent, it is for the legislature to hem in very restricted terms as to when or what circumstances can be modified. Those millets.
For the legislature, that can we say that the legislature has to do it for narrow purposes?
That is for the legislature to do. We may not like it. We may want to have the power. But that just because we want to have the power doesn't mean you have the power. And the legislature may find creative ways as to how to rein in the power of modification when a judicial test is laid down by court. Inevitably, the interpretation of that will become wider and wider and wider as we go through time, with courts all across the country interpreting the judgment of my lords. We saw that with ONGC.
You are proceeding on the assumption
Yes,
that the statute as it now stands doesn't permit.
so that's
You have to first deal with the point
we will, Millets.
that the statute as it now stands forecloses
Correct, Millets.
even the nature of the modification as suggested.
Absolutely. Well, what I'm dealing with the other side is we must keep this in mind
Basic
that
submission is that if there is a power to set aside, it's a wider power. And therefore, if there is a wider power, then a smaller power can be exercised.
It's dealt with my note and I will,
And like Mr. Datar argued, if the legislature wanted a prohibition, then it could have provided a prohibition as has been provided in the Singapore Act.
yes, sir. On that section 5 and Singapore Act, which Mr. Banerjee will address, saying that it is identical. The section 5 of our act is identical to the Singapore Act. And Millers, I will just,
Article 5 of the.
and I'll show one judgment, Millers, of in the Stamp Act case, where this is discussed as to what is the scope of the courts. I mean, there's a lot of discussion has happened about the policy of the act itself. I'll come to all of those, but just quickly address Justice Gavai's